Landlords, it's Ernie. I'm back, and today we're covering the TAA residential apartment lease. We've covered pages 1 through 4, and today we'll take on pages 5 and 6 of the TAA lease. Let's get started. Today's topics cover only 8 sections of the TAA lease. We're from section 26 through 33 in the lease. The first of which has to do with repair requests. Right from the beginning, it's important to recognize that all repair requests should be made in writing. The lease, which is written, requires that your request be submitted by your tenant in writing. Furthermore, this section requires not just the writing, but that it be signed and delivered as required in the lease. If your tenant has called in an order or stopped by and mentioned something, it's not the same effect as if they follow what section 26 of the lease requires, which is a signed written notice delivered properly to the landlord. Section 26.2 requires the tenant to notify the landlord of any defects, particularly those defects like a leak that could lead to additional damages if unaddressed. Section 26.3 and section 26.4 have to do with problems that need to be addressed. 26.3 deals with utilities that need to be repaired, and 26.4 explains how equipment is repaired, particularly after a casualty loss, a storm, a fire, that sort of thing. Insurance companies may need to come in for the claims portion of this, and so it may ultimately cause delay, which is why these important provisions are here for the tenant to review and understand. Furthermore, if a particular loss has been so substantial that the landlord deems that the loss is total, you can have your lease terminated. And so a landlord who deems after a fire or a flood or some kind of wind damage, if a landlord deems under this lease that the unit is a virtual loss or a total loss, the lease itself can be terminated. No additional accommodation would need to be given to the tenant in the event of this kind of loss. For those of you who have enjoyed the video up until this point, don't forget to give us a like. Don't forget also to add your comments below. We always love to hear from you, and if you haven't yet subscribed, please consider subscribing. 27.1 has to do with pets. In fact, it is an absolute prohibition to have any pets in a TAA lease without the written consent of the landlord. This is particularly important because of the potential for damage, as well as safety depending on certain breeds of animals. Section 27 goes on to explain that not just the tenant is liable for any damages caused by a pet or for the presence of a pet on the premises, but even their guests are liable. We've seen sometimes when, grandma comes over and she brings her, her dog. That's not allowed under the terms of this lease unless the landlord is given written permission. The fact that a third party brings an animal to the premises does not absolve the tenant of the liability that may result from it. Additionally, if a pet has to be removed by the landlord, the tenant agrees to cover any of those charges and agrees to compensate the landlord for that removal. Section 28 of the TAA lease has everything to do with the right of the landlord to enter the property. Even if the tenant is there at the time, so long as the landlord can enter peaceably during a reasonable time and in a reasonable manner, there is no prohibition, and the landlord is not required to obtain the permission of the tenant in order to do so. Naturally, if no one is at home in the apartment, a landlord may enter so long as they have a key of their own, and as long as the method and the manner of that entry is reasonable and conducted at a reasonable time. Section 29 of the lease has to do with joint and several liability, so that all of the residents in a given unit are liable together for the actions of each other, which is to say that if one person breaks any term of the lease, everyone has broken the term of the lease. Everyone is subject to the liability based on the actions of any of the residents or their guests during the term of this lease. So the TAA lease will allow in Section 30 subleasing and replacement of tenants. However, it must be understood that such a thing has to be accepted by the landlord in writing, and the tenant cannot simply require the landlord to accept a replacement tenant. If a tenant is leaving and has bargained with the landlord, there may be additional costs, but it is possible to replace a tenant so long as that replacement is done in writing and signed by both parties. In the event that the landlord does agree to a replacement tenant, the previous tenant is no longer welcome back onto the property as a tenant. The deposit that they paid is likely to be transferred to the new tenant, and the new tenant will sign their own lease with the landlord. What a tenant is not allowed to do is not allowed to sublease on their own. They're not allowed to rent out a room or rent out the entire apartment, again, without the written consent of the landlord. Section 31 of the TAA lease explains what the obligations are of the landlord with regard to maintaining the property. This includes maintaining the common areas, being diligent with repairs, particularly those repairs that affect the health and safety of an ordinary tenant. It also goes on to explain the rights of the tenant when the landlord fails to comply with its own agreement. It explains that if a tenant submits a request in writing for a repair for some defect on the premises that affects the health and safety of an ordinary tenant, that the landlord is otherwise obligated to complete that repair satisfactorily. However, if the landlord fails to do this, this section goes on to explain that a subsequent notice can be sent to the landlord, and that certain rights that are available under Chapter 92.056 of the Texas Property Code can come into effect if the landlord continues to fail to remedy the particular defect on the premises. Among the requirements of this section is that the tenant's rent be current and that all of these requests be made in writing. But if a tenant has made a timely request while their rent is current, it is possible for a tenant to terminate their lease with the landlord if the landlord has failed to comply with this particular provision of the TAA lease. Section 32 of the TAA lease has everything to do with the default of the tenant. It explains the kinds of things that the tenant can do that would constitute a default, which means a breach of the lease that would entitle the landlord to certain remedies. Among these remedies is the process of eviction. In the TAA lease, if a tenant is in default and subject to an eviction, a landlord can send a notice to vacate. That notice to vacate instructs the tenant that their ability to possess the property has been terminated, and due to their breach and their default of the lease itself, they are required to leave or be subjected to an eviction lawsuit. Among other remedies that exist for the landlord is the ability to accelerate the entire lease. Acceleration happens when a default has occurred and a tenant is now required to pay for the entire lease upon demand by the landlord. Section 32 goes on to explain additional remedies available to the landlord, including remedies for what is known as holdover, so that when a lease has been properly terminated, a tenant is not allowed to stay beyond the date of that termination. The landlord would have additional remedies, including eviction, for removal of a tenant who has held over beyond the termination of their lease. Along with the threat of eviction, the fee for a holdover tenancy could be an increase in the amount of rent. By default, the TAA lease allows the landlord to charge a 25% increase for any tenant who holds over beyond the date of termination. Section 32 goes on to describe other remedies that may be available to you as the landlord, including the ability to send unpaid amounts to a collection agency, to seek judgment for these unpaid amounts, to exercise certain lockout remedies in accordance with the Texas Property Code. Finally, Section 32 of the TAA lease explains the duty of the parties to mitigate their damages. For the landlord, this means that the landlord will take diligent steps to find a replacement tenant once an original tenant has vacated or has surrendered possession while there are still time on a particular lease. This mitigation of damages is important for the landlord to recognize, because even though a tenant has stopped paying rent, once possession has been surrendered back to the landlord has a duty to fill that empty unit in order to lessen their own damages. Section 33 of the TAA lease refers to the representatives of the landlord. While it is true that many landlords themselves do not interact with tenants, that instead it is agents and management that does most of this work, it's important for the tenant to understand that while these agents represent the landlord, that unless some communication is had in writing, it is otherwise not binding against the landlord. Additionally, just because an agent has not exercised one of the rights that a landlord possesses doesn't mean that the landlord themselves has waived any of these rights. Even if many months have passed without any exercise of a particular right, the landlord still possesses these rights even if their agents have not acted on them at any time. Finally, Section 33 of the TAA lease has what's known as a severability clause. This clause is important because it explains that any provision in the lease that is found to be unenforceable can simply be removed and the rest of the lease stays in place. So this wraps up today's section of the lease. We've got one final part to add where we will explain the remaining parts of the TAA lease. I hope you have enjoyed this. For those of you who are looking to subscribe, you'll see a picture of my face on the screen here, and more content here that you can check out that YouTube seems to think that you will enjoy. But until next time, happy leasing.